Okay, so nandito na naman ang inyong Lolo Ray para ituloy ang pagbabasa natin ng Civil Code. Ngayon naman, ang babasahin natin ay yung Title 6. Mahaba-haba ito. Iisang title lang ng Book 4 pero napakahaba. Ang pamagat nito ay sales, no? Naalala ko dati nung nag-aaral ako, hindi ko pinasukan itong sales na ito dahil yung teacher ko ay matanda na at nagkikwento na lang siya ng buhay niya. Tuwang-tuwa ako dati na marami ako naging teacher na gano'n eh. So, sa madaling salita, marami akong classes sa pag-aaral ng batas ang hindi ko talagang napasukan. O wala akong natutunan. Pero ang dapat sanang ginawa ko, nag-aaral ako. Kaso, masakit sa matang magbasa. Pero subukan natin for our purposes, no? Subukan natin magbasa at ipaliwanag ang batas in layman's term. So, nandito na tayo. Title 6 of Book 4 ng Civil Code of the Philippines. Ang pamagat nito ay Sales. Chapter 1, Nature and Form. Dali lang, iusog natin para medyo, dali lang. Yan. Yan, saan ba ito? Yan, maglagay tayo ng supportang ganyan. Okay. Okay, yan. So, Chapter 1, Nature and Form of the Contract. O bakit contract ang sinabi niya? Ang sales po kasi ay isang uri ng contract. Yun yung tinatawag nating contract of sale. Okay? Article 1458. By the contract of sale, one of the contracting parties obligates himself to transfer the ownership and to deliver a determinate thing, and the other to pay, therefore, a price certain in money or its equivalent. A contract of sale may be absolute or conditional. So, pinaliliwanag lang naman doon, ang kontrata ng sale, yung seller, obligates himself to deliver a determinate or a specific thing. At yun namang buyer, ang required naman is magbayad siya ng a price certain in money or its equivalent. Yun ang sabi sa batas, ano? Article 1459, the thing must be licit and the vendor must have a right to transfer the ownership thereof at the time it is delivered. So, meron na naman tayong, ano tawag dito, hindi maintindihan. Ewan ko sa inyo kung naiintindihan nyo to. Pero ako, ano yung licit? Siguro ang licit is legal. Yun siguro ang meaning niya. Not forbidden or lawful. O, tama nga ako. Yun ay ibig sabihin ng licit. Okay, so dapat yung thing daw, yung binibenta niya ay dapat legal or licit. And the vendor must have a right to transfer the ownership thereof at the time it is delivered. Article 1460, a thing is determinate when it is particularly designated or physically segregated from all other of the same class. So, kunwari, maraming motor, Honda 155, pero itong particular na color, itong particular engine number, particular chassis number, yun yung licit. Yun lang yun. May mga ibang motor na Honda 155 na blue, pero ang ibig sabihin determinate, siya ang pinili na yun. Engine number and chassis number. So, gets nyo yung point, no? So, a thing is determined when it is particularly designated or physically segregated from all other of the same class. The requisite that the thing be determined is satisfied if at the time the contract is entered into, the thing is capable of being made determinate without the necessity of a new or further agreement between the parties. Okay. Article 1461, things having a potential existence. Ito. Things having a potential existence may be the object of the contract of sale. The efficacy of the sale of a mere hope or expectancy is deemed subject to the condition that the thing will come into existence. The sale of a vain hope or expectancy is void. Okay? Hindi ka pwede magbenta ng wala pa naman. Binibenta mo ay pag-asa and expectancy. That is a void contract of sale. Parang yung mga, di ba may mga pre-selling ng subdivision o nagbebenta sila ng mas mababa, pre-selling, hindi pa naitatayo yung bahay, kunwari. Tapos doon sa naitakdang panahon, hindi pa naman doon sa kontrata, nagbayad na ng karampatang amount yung buyer. Tapos makikita niya, hindi pa naitayo yung bahay, hindi pa siya makalipat sa takdang araw na nakasaad sa usapan. O di ba yung kontratang yun ay void. Kasi parang binentahan mo lang ako ng expectancy. I want my money back. Ayan. Article 1462. The goods which form the subject of a contract of sale may be either existing goods owned or possessed by the seller or goods to be manufactured, raised, or acquired by the seller after the perfection of the contract of sale. In this title called future goods. So, meron palang ganun. There may be a contract of sale of goods whose acquisition by the seller depends upon a contingency which may or may not happen. So, ang example niyan is yung bibili ka ng itlog. Di ba? So, pwedeng mangyari yun o hindi. Pwedeng mangitlog yung manok. O pwede namang mategi yung manok na inaasahan mong mangitlog, di ba? Okay, tungo naman tayo sa Article 1463. The sole owner of a thing may sell an undivided interest therein. Okay? Article 1464, in the case of fungible goods, o yung interchangeable ang parts, there may be a sale of an undivided share of a specific mass, though the seller purports to sell and the buyer to buy a definite number, weight, or measure of the goods in the mass, and though the number, weight, or measure of the goods in the mass is undetermined. By such a sale, the buyer becomes owner in common of such a share of the mass as the number, weight, or measure bought bears to the number, weight, or measure of the mass. If the mass contains less than the number, weight, or measure bought, the buyer becomes the owner of the whole mass, and the seller is bound to make good the deficiency from goods of the same kind and quality unless a contrary intent appears. Article 1465. Things subject to a resolutory condition may be the object of the contract of sale. Okay? Article 1466. So, bago tayo magtuloy, ano muna ulit yung resolutory condition? Kasi yung mga subject daw ng resolutory condition ay pwedeng subject ng sale. So, sabi rito, resolutory condition, para sa kaalaman natin, on which has for its object, when accomplished, the revocation of the principal obligation. So, ito for example, I will sell you my crop of cotton if my ship America yung pangalan ng barko, ng ship, does not arrive in the United States within 6 months. My ship arrives in 1 month, my contract with you is revoked. Pag dumating sa loob ng 6 na buwan yung aking barko, revoked na yung kontrata natin. Yun ang resolutory condition. So maganda, may example pa. So maybe the object of the contract of sale. Article 1466. In construing a contract containing provisions characteristic of both the contract of sale and the contract of agency to sell, the essential clauses of the whole instrument shall be considered. Article 1467. A contract for the delivery at a certain price of an article which the vendor in the ordinary course of his business manufactures or procures for the general market, whether the same is on hand at the time or not, is a contract of sale. But if the goods are to be manufactured especially for the customer and upon his special order and not for the general market, it is a contract for a piece of work. Okay, hindi pala yun contract of sale, kundi it's a contract for a piece of work kasi ginawa lang yun not for the general market pero para lamang sa'yo. Ang kadalasan na nangunguha ng contract for a piece of work ay yung mga rich kids. Article 1468. If the consideration of the money consists partly in money, ulitin natin. If the consideration of the contract consists partly in money and partly in another thing, the transaction shall be characterized by the manifest intention of the parties. If such intention does not clearly appear, it shall be considered a barter if the value of the thing given as a part of the consideration exceeds the amount of the money or its equivalent. Otherwise, it is a sale. Okay. Article 1469. In order that the price may be considered certain, it shall be sufficient that it be so with reference to another thing certain, or that the determination thereof be left to the judgment of a special person or persons. Should such person or persons be unable or unwilling to fix it, the contract shall be inefficacious unless the parties subsequently agree upon the price. If the third person or persons acted in bad faith or by mistake, the courts may fix the price. Where such person or persons are prevented from fixing the price or terms by fault of the seller, saan ba ako? Or the buyer, so ulitin natin. When such third person or persons are prevented from fixing the price or terms by fault of the seller or the buyer, the party not in fault may have such remedies against the party in fault as are allowed the seller or the buyer, as the case may be. Okay. So ulitin lang natin ano ibig sabihin ng efficacious. Para lang kompleto yung efficacent. Ano lang alam natin, di ba? In layman's term, sabi ito, effective. Yun ang ibig sabihin. Efficacious. Parang efficacent oil. Effective oil. Ha? Ibig sabihin. So sabi rito, magiging hindi raw effective, inefficacious. Should such a person or persons be unable or unwilling to fix it, the contract shall be inefficacious or ineffective. Yun. Siyempre, hindi certain yung price. Hindi mo alam, di ba? Kailangan sure lahat. Article 1470, gross inadequacy of price does not affect a contract of sale, except as it may indicate a defect in the consent or that the parties really intended a donation or some other act or contract. Article 1471, if the price is simulated, the sale is void, but the act may be shown to have been in reality a donation or some other act or contract. Void raw yung sale na mayroong simulated price. Article 1472, the price of securities, grain, liquids, and other things shall also be considered certain when the price fixed is that which the thing sold would have on a definite day or in a particular exchange or market, or when an amount is fixed above or below the price on such day or in such exchange or market provided said amount certain. Kailangan kasi dito certain lahat, certain ang price, di ba? Yung ibabayad mo sa kanya certain, di ba? A sum certain in money, di ba? Yan ang elements ng ng sale. Article 1473, the fixing of the price can never be left to the discretion of one of the contracting parties. However, if the price fixed by one of the parties is accepted by the other, the sale is perfected. Bibenta ko kunwari sa itong t-shirt ko. Sinabi ko 750, mahal, di ba? Mahal para sa quality niya. Pero tinanggap mo, the sale is perfected. Okay. Article 1474, where the price cannot be determined in accordance with the preceding articles or in any other manner, the contract is inefficacious or walang bisa. However, if the thing or any part thereof has been delivered to and appropriated by the buyer, he must pay a reasonable price therefore. What is a reasonable price is a question of fact dependent on the circumstances of each particular case. Depende naman kasi yung determination ng price sa pagkakagawa. Kunwari ito, pag tinignan mo, simple lang, pero ito pala ay yari sa rare na raw materials, di ba? So, mas mahal siya. Pwedeng ganun. Article 1475, the contract of sale is perfected at the moment there is a meeting of minds. So parang contract, di ba? Kaya nga contract of sale eh. Parang bastos naman ito. Nagtagpo. Kasi ganun na, kaya sabihin mong bastos siya. Nagtagpo yung minds upon the thing which is the object of the contract and upon the price. Okay. From that moment, the parties may reciprocally demand performance subject to the provisions of the law governing the form of contracts. So, upon nagtagpo yung pag-iisip natin sa object at sa price, kunwari ito yung object, bibilin mo sa akin sa halagang 500 pesos, kunwari, nagtagpo tayo, pwede na ako mag-demand sa'yo na, oh, bibigay ko sa'yo ito, bayaran mo na pala ako ng 500. Or pwedeng sabihin mo, binayaran na kita, bigay mo na sa akin yan. Okay. Okay. Article 1476, in the case of a sale by auction, number 1, where goods are put up for sale by auction in lots, each lot is the subject of a separate contract of sale. Ayun kapag ka binibenta, auction in lots, each lot daw is subject of a separate contract of sale. Number 2, a sale by auction is perfected when the auctioneer announces its perfection by the fall of the hammer. Sold, ganyan. Or in other customary manner. Until such announcement is made, any bidder may retract his bid and the auctioneer may withdraw the goods from the sale unless the auction has been announced to be without reserve. Okay, ang reserve po niyan yung price na hindi dapat bababa doon para ibenta niya yung produkto. Number 3, a right to bid may be reserved expressly or expressly by or on behalf of the seller unless otherwise provided by law or by stipulation. Number 4, where notice has not been given that the sale by auction is subject to a right to bid on behalf of the seller, it shall not be unlawful for the seller to bid himself or to employ or induce any person to bid at such sale on his behalf, or for the auctioneer to employ or induce any person to bid at such sale on behalf of the seller, or knowingly to take any bid from the seller or any person employed by him. Any sale contravening this rule may be treated as fraudulent by the buyer. Article 1477, the ownership of the thing sold shall be transferred to the vendee upon the actual or constructive delivery thereof. So ako yung vendor, ako yung nagtitinda nito. So upon transfer, yung ownership is transferred to you, to the vendee, upon the delivery, the actual delivery of the thing sold. Article 1478, the parties may stipulate that ownership in the thing shall not pass to the purchaser until he has fully paid the price. Article 1479, a promise to buy and sell a determinate thing for a price certain is reciprocally demandable. An accepted unilateral promise to buy or to sell a determinate thing for a price certain is binding upon the promisor if the promise is supported by a consideration distinct from the price. Article 1480, any injury to or benefit from the thing sold after the contract has been perfected from the moment of the perfection of the contract to the time of delivery shall be governed by Articles 1163 to 1165 and 1262. This rule shall apply to the sale of fungible things made independently and for a single price or without consideration of their weight, number, or measure. Should fungible things be sold for a price fixed according to weight, number, or measure, the risk shall not be imputed to the vendee until they have been weighed, counted, or measured and delivered unless the latter has incurred in delay. Article 1481, in the contract of sale of goods by description or by sample, the contract may be rescinded if the bulk of the goods delivered do not correspond with the description or the sample. Ito, maganda to sa mga online seller And if the contract be by sample as well as description, it is not sufficient that the bulk of goods correspond with the sample if they do not also correspond with the description. The buyer shall have a reasonable opportunity of comparing the bulk with the description or the sample. Okay? So, kailangan, kung namili ka, usong-uso ngayon ng online selling, online shopping. Okay, so, kailangan kung ano yung description doon, pag dineliver sa'yo, pareho. O kahit na bulk pa yung dineliver sa'yo, dapat it corresponds with the description. Article 1482, Whenever earnest money is given in a contract of sale, it shall be considered as part of the price and as proof of the perfection of the contract. Article 1483, subject to the provisions of the Statute of Frauds and of any other applicable statute, a contract of sale may be made in writing or by word of mouth, or partly in writing and partly by word of mouth, or may be inferred from the conduct of the parties. Okay. Article 1484, in a contract of sale of personal property, the price of which is payable in installments, the vendor o yung nagtitinda may exercise any of the following remedies. Number 1, exact fulfillment of the obligation should the vendee fail to pay. So, kunin niya yung fulfillment ng obligation. Number 2, cancel the sale should the vendee's failure to pay cover 2 or more installments. Pag di ka nakabayad ng 2 or more installments, pwede niya palang i-cancel. Number 3, foreclose the chattel mortgage on the thing sold if one has been constituted should the vendee's failure to pay cover 2 or more installments. Di ka nakabayad ng 2 or more installments. In this case, he shall have no further action against the purchaser to recover any unpaid balance of the price. Any agreement to the contrary shall be void. Okay? Yan ang remedyo ng vendor. Article 1485. The preceding articles shall be applied to contracts purporting to be leases of personal property with option to buy when the lessor has deprived the lessee of the possession or enjoyment of the thing. Kasi merong mga lease ng personal property with an option to buy. So yung nagdaang property daw shall also be applied to such contracts. Article 1486. In the case referred to in two preceding articles, a stipulation that the installments or rents paid shall not be returned to the vendee or lessee shall be valid insofar as the same may not be unconscionable under the circumstances. Okay. Article 1487. The expenses for the execution and registration of the sale shall be borne by the vendor unless there is a stipulation to the contrary. Article 1488. The expropriation of property for public use is governed by special laws. Merong mga special law na nakatakda yan para sa expropriation ng mga property for public use. Tungo na tayo sa Chapter 2, Capacity to Buy or Sell. Article 1489, all persons who are authorized in this code to obligate themselves may enter into a contract of sale, saving the modifications contained in the following articles. Where necessaries are those sold and delivered to a minor or other person without capacity to act, he must pay a reasonable price therefor. Necessaries are those referred to in Article 290. Okay? Article 1490, the husband and the wife cannot sell property to each other. As a general rule, bawal sila magbenta ng property sa isa't isa except Number 1, when a separation of property was agreed upon in the marriage settlements. Kunwari yung example ni Chris Aquino at ni James Yap, meron silang prenup. Pwede sila magbenta ng ari-arian sa isa't isa. Number 2, when there has been a judicial separation judicial separation of property under Article 191. Article 1491, the following persons cannot acquire by purchase, even at a public or judicial auction, either in person or through the mediation of another. Ito yung mga hindi pa pwedeng mag-acquire. Number 1, the guardian, the property of the person or persons who may be under his guardianship. Kung guardian ka, you cannot acquire, di ka pwede mag-participate do sa property ng ward mo. Number 2, agents, the property whose administration or sale may have been entrusted to them unless the consent of the principal has been given. Sales agent ka, hindi ka pwede mag-acquire ng property unless binigyan ka ng consent ng principal. Number 3, executors and administrators, the property of the estate under the administration. Bawal yan. Number 4, public officers and employees as to the property of state or of any subdivision thereof, or of any government-owned or controlled corporation or institution, the administration of which has been entrusted to them. This provision shall apply to judges and government experts who, in any manner whatsoever, take part in the sale. Bawal sila. Number 5, justices, judges, prosecuting attorneys, clerks of superior and inferior courts, and other officers and employees connected with the administration of justice, the property and rights in litigation or levied upon an execution before the court, within whose jurisdiction or territory they exercise their respective functions. Bawal sila, pero kadalasan ang ginagawa nito, nagtatawag sila ng mga tropa nila or kamag-anak na may pera. This prohibition includes the act of acquiring by assignment and shall apply to lawyers with respect to the property and rights which may be the object of any litigation in which they may take part by virtue of their profession. Number 6, any other specially disqualified by law. So pag itinakda ng batas na ikaw ay disqualified, you cannot acquire property. Sa ganong paraan, okay? Article 1492, the prohibitions in the two preceding articles are applicable to sales in legal redemption, compromises, and renunciations. Tungo na tayo sa chapter 3, effects of the contract when the thing sold has been sold. Okay? Article 1493, if at the time the contract of sale is perfected, the thing which is the object of the contract has been entirely lost, the contract shall be without any effect. But if the thing should have been lost in part only, the vendee may choose between withdrawing from the contract and demanding the remaining part, paying its price in proportion to the total sum agreed upon. So, kunwari, namimili ako ng kambal na unan, magkadikit, pero nawala yung kalahati. Ako, pwede ako mamili na mag-withdraw na ako sa contract, di ko na yung bibilin, or bibilin ko na lang yung natitirang kalahati ayon sa presyo na yon. Okay? Article 1494, where the parties purport a sale of specific goods and the goods without the knowledge of the seller have perished in part or have wholly or in a material part so deteriorated in quality as to be substantially changed in character, the buyer may, at his option, treat the sale, number 1, remedies to ng buyer, as avoided, or number 2, as valid in all of the existing goods, or in so much thereof as have not deteriorated, and as binding the buyer to pay the agreed price for the goods in which the ownership will pass if the sale was indivisible. If the sale was divisible. Hindi indivisible, ha? Okay, Chapter 4, Obligations of the Vendor, Section 1. Ito yung obligasyon ng nagtitinda. General Provisions, Article 1495. The vendor is bound to transfer the ownership of and deliver as well as warrant the thing which is the object of the sale. Number 2, Article 1496. The ownership of the thing sold is acquired by the vendee from the moment it is delivered to him in any of the ways specified in Articles 1497 to 1501 or in any other manner signifying an agreement that the possession is transferred from the vendor to the vendee. Okay? From the seller to the buyer. Section 2, Delivery of the thing sold. Article 1497. The thing sold shall be understood as delivered when it is placed in the control and possession of the vendee o ng buyer. Yun ang ibig sabihin nun. Article 1498. When the sale is made through a public instrument, the execution thereof shall be equivalent to the delivery of the thing which is the object of the contract, if from the deed the contrary does not appear or cannot clearly be inferred. With regard to movable property, its delivery may also be made by the delivery of the keys of the place or depository where it is stored or kept. Article 1499. The delivery of movable property may likewise be made by the mere consent or agreement of the contracting parties if the thing sold can be transferred to the possession of the vendee at the time of the sale or if the latter already had it in his possession for any other reason. Article 1500. There may also be tradition constitum possessorium. Okay? So, alamin natin, tradisyon constitutum possessorium. Traditional possession ba yun? Tradition constitutum possessorium. Ano ibig sabihin nito? What does that mean? Ibig sabihin nito ay the change in intention of one having legal possession of real or personal property whereby the original possessor of the property remains in control but transfers the legal possession to another. So, ang tradisyon, constitutum possessorium ay pinapayagan ng batas. Kunwari ako, may pag-aari ako, pinagbenta ko na sa iyo yung lupa ko, inilipat ko na sa iyo yung papeles ng lupa, ikaw na may-ari, pero nasa akin pa rin ang kanyang possession dahil kunwari, hindi mo naman siya mahaharap gamitin siya ngayon. Iyon ang tradisyon constitutum possessorium. At pinapayagan daw yun ng batas. Okay? Article 1501, with respect to incorporeal property, the provision of the first paragraph of Article 149H shall govern. In any other case, wherein said provisions are not applicable, the placing of the titles of ownership in the possession of the vendee or the use by the vendee of his rights with the vendor's consent shall be understood as delivery. So, alamin natin ang ibig sabihin ng incorporeal. Tayo mga layman, hindi natin alam yan. Tayo mga simpleng tao, ano namang malay natin dito sa incorporeal property ng Sus Mariosep. Ibig niya sabihin ay property without a body that cannot be touched and picked up, such as a right to something. Stocks and shares are incorporeal, personal, or movable property, as are copyrights and patents. To transfer such property, as assignation is usually required. Ano ba pronunciation ito? Assignation or assignation is usually required. So, alam na natin ang incorporeal property. Ang example niya, yung mga stocks, hindi mo pwedeng hawakan. Stocks, copyright, yan. Okay, meron naman kasing rules dyan eh. Like, kunwari, sa pagbibenta ng stocks, merong rules doon eh. Upon yung payment, syempre, ng corresponding stocks, delivery ng stock certificate, and then, napunta tayo dyan siguro sa susunod. Article 1502, when goods are delivered to the buyer on sale or return, to give the buyer an option to return the goods instead of paying the price, the ownership passes to the buyer of delivery, but he may revest the ownership in seller by returning or tendering the goods within the time fixed in the contract, or if no time has been fixed, within a reasonable time. When goods are delivered to the buyer on approval or on trial or on satisfaction or other similar terms, the ownership therein passes to the buyer. Number 1, when he signifies his approval or acceptance to the seller or does any other act adopting the transaction. Number 2, if he does not signify his approval or acceptance to the seller but retains the goods without giving notice of rejection, then if a time has been fixed for the return of the goods on the expiration of such time, and if no time has been fixed on the expiration of a reasonable time. What is a reasonable time is a question of fact. Article 1503, when there is a contract of sale of specific goods, the seller may, by the terms of the contract, reserve the right of possession or ownership in the goods until certain conditions have been fulfilled. The right of possession or ownership may be thus reserved, notwithstanding the delivery of the goods to the buyer or to a carrier or other bailee for the purpose of transmission to the buyer. Where goods are shipped and the bill of lading, the goods are deliverable to the seller or his agent, or to the order of the seller or of his agent. The seller thereby reserves the ownership in the goods. But if except for the form of the bill of lading, the ownership would have passed to the buyer on shipment of the goods. The seller's property in the goods shall be deemed to be only for the purpose of securing performance by the buyer of his obligations under the contract. Where goods are shipped and by the bill of lading, the goods are deliverable to order of the buyer or of his agent, but possession of the bill of lading is retained by the seller or his agent, the seller thereby reserves a right to the possession of the goods as against the buyer. Where the seller of goods draws on the buyer for the price and transmits the bill of exchange and bill of lading together to the buyer to secure acceptance or payment of the bill of exchange, the buyer is bound to return the bill of lading if he does not dishonor the bill of exchange, and if wrongfully retains the bill of lading, he acquires no added right thereby. If, however, the bill of lading provides that the goods are deliverable to the buyer or to the order of the buyer, or endorsed in blank, or to the buyer by the consignee named therein, one who purchases in good faith for value the bill of lading or goods from the buyer will obtain the ownership in the goods, although the bill of exchange has not been honored, provided that such purchaser has received delivery of the bill of lading endorsed by the consignee named therein, or of the goods without notice of the facts making the transfer wrongful. Haba, no? Article 1504. Unless otherwise agreed, the goods remain at the seller's risk until the ownership therein is transferred to the buyer. But when the ownership therein is transferred to the buyer, the goods are at the buyer's risk, whether actual delivery has been made or not, except that, number one, where delivery of the goods has been made to the buyer or to a bailee for the buyer in pursuance of the contract, and the ownership in the goods has been retained by the seller merely to secure performance by the buyer of his obligations under the contract, the goods are at the buyer's risk from the time of such delivery. Number two, where actual delivery has been delayed through the fault of either the buyer or seller, the goods are at the risk of the party at fault. Okay, so sino may kasalanan, sino may partido na may kasalanan ay siyang liable. Article 1505. Subject to the provisions of this title, where goods are sold by a person who is not the owner thereof, hindi ikaw may-ari pero ikaw ang nagbenta, and who does not sell them under authority or with the consent of the owner, walang pahintulot, binenta mo, the buyer acquires no better title to the goods than the seller had, unless the owner of the goods is by his conduct precluded from denying the seller's authority to sell. Nothing in this title, however, shall affect, number one, the provisions of any Factors Act recording laws or any other provision of law enabling the apparent owner of goods to dispose of them as if he were the true owner. Therefore, ibig na sabihin, kunwari, mayroong batas na nagpumapayag doon sa apparent owner. Hindi naman siya talaga yung owner. Siya lang yung apparent owner. Pero binenta niya, kung may pumapayag na batas na yon, then hindi siya gabal ang code na ito. Number two, the validity of any contract of sale under statutory power of sale or under the order of a court of competent jurisdiction. Number three, purchases made in a merchant store or in fairs or markets in accordance with the Code of Commerce and special laws. Okay. So, while nothing in this title shall affect yung mga nabanggit na yun. Article 1506, where the seller of goods has a voidable title thereto, but his title has not been avoided at the time of the sale, the buyer acquires a good title to the goods provided he buys them in good faith for value and without notice of the seller's defect of title. Article 1507, a document of title in which it is stated that the goods referred to therein will be delivered to the bearer or to the order of any person named in such document is a negotiable document of title. Okay. Article 1508, a negotiable document of title may be negotiated by delivery, number one, whereby the terms of the documents the carrier, warehouseman, or other bailee issuing the same undertakes to deliver the goods to the bearer. Alam naman na natin kung sino si bailee, siya yung sa kanya in-entrust yung pangangalaga ng isang personal property. At siya ang nag-undertake to deliver the goods to the bearer, o sa may hawak ng negotiable instrument. Or number two, whereby the terms of the document the carrier, warehouseman, or other bailee issuing the same undertakes to deliver the goods to the order of a specified person, and such person or a subsequent endorsee of the document has endorsed it in blank or to the bearer. Whereby the terms of a negotiable document of title the goods are deliverable to bearer, or where a negotiable document of title has been endorsed in blank or to bearer, any holder may endorse the same to himself or to any specified person, and in such case the document shall thereafter be negotiated only by the endorsement of such endorsee. Article 1509, A negotiable document or title may be negotiated by the endorsement of the person to whose order the goods are by the terms of the document deliverable. Such endorsement may be in blank, to bearer, or to a specified person. If endorsed to a specified person, it may be again negotiated by the endorsement of such person in blank, to bearer, or to another specified person, period. Subsequent negotiations may be made in like manner. Article 1510. If a document of title which contains an undertaking by a carrier, warehouseman, or other bailee to deliver the goods to bearer, to a specified person, or order of a specified person on which contains words of like import, has placed upon it the words not negotiable, non-negotiable, or the like, such document may nevertheless be negotiated by the holder and is a negotiable document of title with the meaning of this title. But nothing in this title contained shall be construed as limiting or defining the effect upon the obligations of the carrier, warehouseman, or other bailee issuing a document of title or placing thereon the words not negotiable, non-negotiable, or the like. So, ang mga usap doon, yung mercantile law. Basta ibig nila namang sabihin dito, ang mga batas na ito ay kumbaga laging in support of one another. Hindi niya pwedeng harangan yung ibang mga special laws for a specific purpose. Article 1511, a document of title which is not in such form that it can be negotiated by delivery may be transferred by the holder by delivery to a purchaser or donee. A non-negotiable document cannot be negotiated, and the endorsement of such a document gives the transferee no additional right. Article 1512. A negotiable document of title may be negotiated, number 1, by the owner therefore, or number 2, by any person to whom the possession or custody of the document has been entrusted by the owner, if, by the terms of the document, the bailee issuing the document undertakes to deliver the goods to the order of the person to whom the possession or custody of the document has been entrusted, or if at the time of such entrusting, the document is in such form that it may be negotiated by delivery. Article 1513. A person to whom a negotiable document of title has been duly negotiated acquires thereby, number 1, such title. Ito yung na-acquire niya. Kasi, anong tawag dito? Duly negotiated sa kanya yung isang negotiable instrument. So, he acquires, number 1, such title to the goods as the person negotiating the document to him had or had the ability to convey to a purchaser in good faith for value, and also such title to the goods as the person to whose order the goods were to be delivered by the terms of the document had or had the ability to convey to a purchaser in good faith for value, and number 2, the direct obligation of the bailee issuing the document to hold possession of the goods for him according to the terms of the document as fully as if such bailee had contracted directly with him. It's as if diretsa ka nakipagkontrata sa kanya. Article 1514. A person to whom a document or title has been transferred but not negotiated acquires thereby, as against the transfer, the title of the goods subject to the terms of any agreement with the transferor. If the document is non-negotiable, such person also acquires the right to notify the bailee who issued the document of the transfer thereof, and thereby to acquire the direct obligation of such bailee to hold possession of the goods for him according to the terms of the document. Prior to the notification of such bailee by the transfer or transferee of a non-negotiable document of title, the title of the transferee to the goods and the right to acquire the obligation of such bailee may be defeated by the levy of an attachment of execution upon the goods by a creditor. Ayan. Pwedeng matalo yun kapag ka mayroong pinag-uutangan, pinagkakautangan, tapos nag-levy siya. Levy on attachment of execution by a creditor or of the transferor, or by a notification to such bailee by the transferor or a subsequent purchaser from the transfer of a subsequent sale of the goods by the transferor. Article 1515. where a negotiable document of title is transferred for value by delivery, and the endorsement of the transfer is essential for negotiation. The transferee acquires a right against the transfer to compel him to endorse the document unless a contrary intention appears. The negotiation shall take effect as of the time when the endorsement is actually made. Article 1516, 1516, a person who, for value, negotiates or transfers a document of title by endorsement or delivery, including one who assigns for value a claim secured by a document of title unless a contrary intention appears, warrants, number one, that the document is genuine. Number two, that he has a legal right to negotiate or transfer it. Number three, that he has knowledge of no fact which would impair the validity or worth of the document. And number four, that he has right o meron siyang karapatan to transfer the title to the goods, and that the goods are merchantable or fit for a particular purpose whenever such warranties would have implied if the contract of the parties had been to transfer without a document of title the goods represented thereby. Article 1517. The endorsement of a document of title shall not make the endorser liable for any failure on the part of the bailee who issued the document or previous endorsers thereof to fulfill their respective obligations. Article 1518. The validity of the negotiation of a negotiable document of title is not impaired by the fact that the negotiation was a breach of duty on the part of the person making the negotiation, or by the fact that the owner of the document was deprived of the possession of the same by loss, theft, fraud, accident, mistake, duress, or conversion, if the person to whom the document was negotiated or the person to whom the document was subsequently negotiated paid value thereof in good faith without notice of the breach of duty or loss, theft, fraud, accident, mistake, duress, or conversion. Article 1519. If goods are delivered to a bailee, o yun sa pangangalaga ni bailee, ha? Kasi si bailor, tandaan natin si bailor, parang piyansa yan ni bail. Si bailor, binibigay niya yung pangangalaga ng isang property kay bailee, temporarily, pangalagaan. Ganun ang logic nun. If goods are delivered to a bailee by the owner or by a person whose act in conveying the title to them to a purchaser in good faith for value would bind the owner, and a negotiable document of title is issued for them, they cannot thereafter, while in possession of such bailee, be attached by garnishment or otherwise, or be levied under an execution unless the document be first surrendered to the bailee or its negotiation enjoined. Okay. The bailee shall in no case be compelled to deliver up the actual possession of the goods until the document is surrendered to him or impounded by the court. Okay? So hanggat hindi mo sinusurrender to the bailee yung dokumento mo, hanggat hindi mo kinakalaban yung dokumento ni bailee, yun ang ibig sabihin. Or hanggat hindi ito nai-impound ng korte. Article 1520. A creditor whose debtor is the owner of a negotiable document of title shall be entitled to such aid from courts of appropriate jurisdiction by injunction and otherwise in attaching such document or in satisfying the claim by means thereof as is allowed at law, or in equity in regard to property which cannot readily be attached or levied upon by ordinary legal process. Article 1521. Whether it is for the buyer to take possession of the goods or of the seller to send them to the buyer is a question depending in each case on the contract, express or implied, between the parties. Apart from any such contract, express or implied, or usage of trade to the contrary, the place of delivery is the seller's place of business if he has one, and if not, his residence. But in case of a contract of sale of specific goods, which to the knowledge of the parties when the contract or the sale was made were in some other place, then that place is the place of delivery. Where by a contract of sale, the seller is bound to send the goods to the buyer, but no time for sending them is fixed, the seller is bound to send them within a reasonable time. Kung walang naka-fix na oras, kailangan i-send mo to within a reasonable time. Where the goods at the time of sale are in the possession of a third person, the seller has not fulfilled his obligation to deliver to the buyer unless and until such third person acknowledges o kilalanin niya to the buyer that he holds the goods on the buyer's behalf. Demand or tender of delivery may be treated as ineffectual unless made at a reasonable hour. What is a reasonable hour is a question of fact. Unless otherwise agreed, the expenses of and incidental to putting the goods into a deliverable state must be borne by the seller. Article 1522. Where the seller delivers to the buyer a quantity of goods less than he contracted to sell, the buyer may reject them, but if the buyer accepts or retains the goods so delivered, knowing that the seller is not going to perform the contract in full, he must pay for them at the contract rate. If, however, the buyer has used or disposed of the goods delivered before he knows that the seller is not going to perform his contract in full, the buyer shall not be liable for more than the fair value to him of the goods so received. Where the seller delivers to the buyer a quantity of goods larger than he contracted to sell, the buyer may accept the goods included in the contract and reject the rest. If the buyer accepts the whole of the goods so delivered, he must pay for them at the contract rate. Where the seller delivers to the buyer the goods he contracted to sell mixed with goods of a different description not included in the contract, the buyer may accept the goods which are in accordance with the contract and reject the rest. Siyempre, may mga sinama siya na hindi naman nakasaad sa usapan. In the preceding two paragraphs, if the subject matter is indivisible, the buyer may reject the whole of the goods. The provisions of this article are subject to any usage of trade, special agreement, or course of dealing between the parties. Article 1523. Where, in pursuance of a contract of sale, the seller is authorized or required to send the goods to the buyer, delivery of the goods to a carrier, whether named by the buyer or not, for the purpose of transmission to the buyer is deemed to be a delivery of the goods to the buyer, except in the case provided for in Article 1503. First, second, and third paragraphs, or unless a contrary intent appears. Unless otherwise authorized by the buyer, the seller must make such contract with the carrier on behalf of the buyer as may be reasonable, having regard to the nature of the goods and the other circumstances of the case. If the seller omits so to do, and the goods are lost or damaged in course of transit, the buyer may decline to treat the delivery to the carrier as a delivery to himself, or may hold the seller responsible in damages. Unless otherwise agreed, where goods are sent by the seller to the buyer under circumstances in which the seller knows or ought to know that it is usual to insure, the seller must give such notice to the buyer as may enable him to insure them during their transit, and if the seller fails to do so, the goods shall be deemed to be at his risk during transit. Article 1524. The vendor shall not be bound to deliver the thing sold if the vendee has not paid him the price or if no period for the payment has been fixed in the contract. Article 1525, the seller of goods is deemed to be an unpaid seller within the meaning of this title. Number 1, when the whole of the price has not been paid or tendered, and number 2, when a bill of exchange or other negotiable instrument has been received as conditional payment and the condition on which it was received has been broken by reason of the dishonor of the instrument, the insolvency of the buyer, or otherwise. In Articles 1525 to 1535, the term seller includes an agent of the seller to whom the bill of lading has been endorsed, or a consignor or agent who has himself paid or is directly responsible for the price, or any other person who is in the position of a seller. Article 1526, subject to the provisions of this title, notwithstanding that the ownership in the goods may have passed to the buyer, The unpaid seller of goods as such has, number one, a lien or claim on the goods or right to retain them for the price while he is in possession of them. Number two, in case of the insolvency of the buyer, a right of stopping the goods in transitu after after he has parted with the possession of them. Number three, a right of resale as limited by this title. And number four, a right to rescind the sale as likewise limited in by this title. Where the ownership in the goods has not passed to the buyer, the unpaid seller has, in addition to his other remedies, a right of withholding delivery similar to and coextensive with his rights of lien or claim and stoppage in transitu where the ownership has passed to the buyer. Pwede niyang ipatigil. He can stop the transit. Article 1527. Subject to the provisions of this title, the unpaid seller of goods who is in possession of them is entitled to retain possession of them until payment or tender of the price in the following cases, namely, number one, hanggat di ka binabayaran, number one, where the goods have been sold without any stipulation as to credit. Number two, where the goods have been sold on credit but the term of credit has expired. And number three, where the buyer becomes insolvent. The seller may exercise his right of lien or right of claim, notwithstanding that he is in possession of the goods as agent or bailee for the buyer. Article 1528. Where an unpaid seller has made part delivery of the goods, he may exercise his right of lien on the remainder unless such part delivery has been made under such circumstances as to show an intent to waive the lien or right of retention. Article 1529, the unpaid seller of goods loses his lien o yung claim niya na nawawala yung claim niya kahit na hindi pa siya nabayaran. Seller to ha. Ang isang seller na hindi pa nabayaran, nawawala ang claim niya kapag number one, when he delivers the goods to a carrier or other bailee for the purpose of transmission to the buyer without reserving the ownership in the goods or the right to the possession thereof. Number two, when the buyer or his agent lawfully obtains possession of the goods. And number three, by waiver thereof. The unpaid seller of goods, having a lien thereon, does not lose his lien by reason only that he has obtained judgment or decree for the price of the goods. Article 1530, subject to the provisions of this title, when the buyer of goods is or becomes insolvent, the unpaid seller who has parted with the possession of the goods has the right of stopping them in transitu, patitigilan yung pagbabiyahe sa goods. That is to say, he may resume possession of the goods at any time while they are in transit, and he will then become entitled to the same rights in regard to the goods as he would have had if he had never parted with the possession. Article 1531. Goods in transit within the meaning of the preceding article are, number one, from the time when they are delivered to a carrier by land, water, or air or other bailee for the purpose of transmission to the buyer, until the buyer or his agent in that behalf takes delivery of them from such carrier or other bailee. Number two, if the goods are rejected by the buyer and the carrier or if the goods are rejected by the buyer and the carrier or other bailee continues in possession of them, even if the seller has refused to receive them back, goods are no longer in transit within the meaning of the preceding article. Okay, masyado akong nagtuloy-tuloy. So, dalawa lamang yung goods in transit. Sabi na, wala kasing space dito eh. Goods are no longer in transit within the meaning of the preceding article. Number one, if the buyer or his agent in that behalf obtains delivery of the goods before their arrival at the appointed destination. Nasa kanila na yung delivery ng good bago pa pumunta sa destinasyon. Paano kaya yun? And number two, if after the arrival of the goods at the appointed destination, the carrier or other bailee acknowledges to the buyer or his agent that he holds the goods on his behalf and continues in possession of them as bailee for the buyer or his agent, and it is immaterial the further destination for the goods may have been indicated by the buyer. Number three, if the carrier or other bailee wrongfully refuses to deliver the goods to the buyer or his agent in that behalf, period. If the goods are delivered to a ship, freight train, truck, or airplane chartered by the buyer, it is a question depending on the circumstances of the particular case, whether they are in the possession of the carrier as such or as agent of the buyer. If part delivery of the goods has been made to the buyer or his agent in that behalf, the remainder of the goods may be stopped in transitu unless such part delivery has been under such circumstances as to show an agreement with the buyer to give up possession of the whole of the goods. Okay. Mamaya, balik tayo sa Article 1532 ha. Sandali lang, dyan lang kayo. Okay, tayo muling nagbabalik para basahin ang Article 1532 naman. Okay. Minsan hindi ko na alam kung anong binabasa ko. Sale. Ayan, no? Article 1532. The unpaid seller may exercise his right of stoppage in transitu. Ayan, lumabo. Dali lang lumabo yung phone ko eh. Yeah. Okay. The unpaid seller may exercise his right of stoppage in transitu either by obtaining actual possession of the goods or by giving notice of his claim to the carrier or other bailee in whose possession the goods are. Such notice may be given either to the person in actual possession of the goods or to his principal. In the latter case, the notice to be effectual must be given at such time and under such circumstances that the principal, by the exercise of reasonable diligence, may prevent a delivery to the buyer. When notice of stoppage in transit is given by the seller to the carrier or other bailee in possession of the goods, he must redeliver the goods to or according to the directions of the seller. The expenses of such delivery must be borne by the seller. If, however, a negotiable document of title representing the goods has been issued by the carrier or other bailee, he shall not be obliged to deliver or justified in delivering the goods to the seller unless such document is first surrendered for cancellation. Yan, medyo komplikado ng konti ha. Article 1533. Where the goods are of perishable nature or where the seller expressly reserves the right of resale in case the buyer should make a default or where the buyer has been in default in the payment of the price for an unreasonable time, an unpaid seller having a right of lien or claim or having stopped the goods in transitu may resell the goods. He shall not thereafter be liable to the original buyer upon the contract of sale or for any profit made by such resale, but may recover from the buyer damages for any loss occasioned by the breach of the contract of sale. Where a resale is made as authorized in this article, the buyer acquires a good title as against the original buyer. It is not essential to the validity of resale that notice of an intention to resell the goods be given by the seller to the original buyer. But where the right to resell is not based on the perishable nature of the goods or upon an express provision of the contract of sale, the giving or failure to give such notice shall be relevant in any issue involving the question whether the buyer had been in default for an unreasonable time before the resale was made. It is not essential to the validity of a resale that notice of the time and place of such resale should be given by the seller to the original buyer. The seller is bound to exercise reasonable care and judgment in making a resale and subject to this requirement may make a resale either by public or private sale. He cannot, however, directly or indirectly buy the goods. Article 1534. An unpaid seller having the right of lien or having stopped the goods in transitu may rescind the transfer of title and resume the ownership in the goods where he expressly reserved the right to do so in case the buyer should make default or where the buyer has been in default in the payment of the price for an unreasonable time. The seller shall not thereafter be liable to the buyer upon the contract of sale, but may recover from the buyer damages for any loss occasioned by the breach of contract. The transfer of title shall not be held to have been rescinded by an unpaid seller until he has manifested by notice to the buyer or by some other overt act an intention to rescind. It is not necessary that such overt act should be communicated to the buyer, but the giving or failure to give notice to the buyer of the intention to rescind shall be relevant in any issue involving the question whether the buyer had been in default for an unreasonable time before the right of rescission was asserted. Article 1535, subject to the provisions of this title, the unpaid seller's right of lien or stoppage in transitu is not affected by any sale or other disposition of the goods which the buyer may have made unless the seller has assented thereto. O, kailangan mag-assent thereto. If, however, a negotiable document of title has been issued for goods, no seller's lien or right of stoppage in transitu shall defeat the right of any purchaser for value in good faith to whom such document has been negotiated, whether such negotiation be prior or subsequent to the notification to the carrier or other bailee who issued such document of the seller's claim to a lien or right of stoppage in transitu. Article 1536. The vendor is not bound to deliver the thing sold in case the vendee should lose the right to make use of the terms as provided in Article 1198. Article 1537. The vendor is bound to deliver the thing sold and its accessions and accessories in the condition in which they were upon the perfection of the contract. All the fruits shall pertain to the vendee from the day on which the contract was perfected. Article 1538. In case of loss, deterioration, or improvement of the thing before its delivery, the rules in Article 1189 shall be observed, the vendor being considered the debtor. Article 1539. The obligation to deliver the thing sold includes that of placing in the control of the vendee. Ilalagay mo sa pagkokontrol ng vendee o yung bumibili ng buyer. All that is mentioned in the contract in conformity with the following rules. If the sale of real estate should be made with a statement of its area at the rate of a certain price for a unit of measure or number, the vendor shall be obliged to deliver to the vendee, if the latter should demand it, all that may have been stated in the contract. But should this be not possible, the vendee may choose between a proportional reduction of the price and the rescission of the contract, provided that, in the latter case, the lack in the area be not less than 1/10 of that stated. The same shall be done even when the area is the same, if any part of the immovable is not of the quality specified in the contract. The rescission in this case shall only take place at the will of the vendee when the inferior value of the thing sold exceeds 1/10 of the price agreed upon. Nevertheless, if the vendee o yung bumibili, yung bumibili would not have bought the immovable had he known of its smaller area of inferior quality, he may rescind the sale. Okay. Binibili kong area, di ko naman yan bibilin kung alam kong ganyan lang kaliit yan. Parang ganon. Article 1540. If in the case of the preceding article, there is a greater area or number in the immovable than that stated in the contract, the vendee may accept the area included in the contract and reject the rest. If he accepts the whole area, he must pay for the same at the contract rate. Kaya maganda, tinitignan mo muna talaga yung binibili mo, no? Article 1541. The provisions of the two preceding articles shall apply to judicial sales. Okay. Article 1542. In the sale of real estate made for a lump sum and not at the rate of a certain sum for unit of measure or number, there shall be no increase or decrease of the price, although there be a greater or less area or number than that stated in the contract. The same rules shall be applied when two or more immovables are sold for a single price. But if, besides mentioning the boundaries, which is indispensable in every conveyance of real estate, its area or number should be designated in the contract, the vendor shall be bound to deliver all that is included within said boundaries, even when it exceeds the area or number specified in the contract. And should he not be able to do so, he shall suffer a reduction in the price in proportion to what is lacking in the area or number, unless the contract is rescinded because the vendee does not accede to the failure to deliver what has been stipulated. Okay. Article 1543. The actions arising from Articles 1539 and 1542 shall prescribe in 6 months counted from the day of delivery. Article 1544. If the same thing should have been sold to different vendees, the ownership shall be transferred to the person who may have first taken possession thereof in good faith if it should be movable property. Should it be movable property, the ownership shall belong to the person acquiring it who in good faith first recorded it in the registry of property. Should there be no inscription, the ownership shall pertain to the person who in good faith was first in the possession, and in the absence thereof to the person who presents the oldest title, provided there is good faith. Okay, magtungo na tayo sa Section 3, Conditions and Warranties. 1545. Sus Maria Josep, ang dami pa nito. 1545. Ay, saus. Ang dami pa. O sige, basahin natin. Napakarami pa nito. 15, sana ako? Ayun, okay. 1545, okay. Ayan, so dito tayo magtatapos kasi nakita ko, napakarami pa nito. 1 oras na. So, pagod na rin ako. So, next time, magbabalik tayo sa Title 6 pa rin. Article 1545, okay. Tatalakayin natin yung conditions and warranties. Okay. Sumuli, ito nga pala si Lolo Ray at sana ay kahit pa paano nag-enjoy kayo and sana meron tayo pare-pareho natutunan sa pagbabasa natin ng mga probisyon ng batas at sa pagpipilit nating ipaliwanag ito in layman's term. So God bless and good night. Ingat kayong lahat.